Let's shift to another pathway. This is a very important one: fair and due process. This actually impacts everyone on campus. Process is so important, and it's often entirely intermingled with substance. Deep in our hearts as educators, I think we believe in the need to deliver fair, and sometimes we use the legal term due process. Of course, figuring out what that means is the real challenge. The details are often where we diverge a little bit. Shall we start this by pointing out that when higher education became sensitive to the need to provide fair process under law during the civil rights period, we looked at that time, back in the 60s and 70s, for help from lawyers. And lawyers have guided us in our conceptualization of what fair and due process looks like. It may be that we've arrived at a place where we need to rethink how we approach the concept of fair and due process and reclaim some of our educational power and even our educational vision around fair and due process. But let me step to the law for a minute, and then we'll come back to that thought. In the law, we distinguish between so-called procedural and substantive due process. Procedural due process, I'm sure, makes intuitive sense to just about everyone. It often translates to nothing more complicated than the legal mandate that you should have notice of charges against you and an opportunity to be heard. Notice and hearing, notice and opportunity to be heard are real basics of procedural process in almost any situation. Substantive due process is something we learn in law school, and it's sort of weird. It almost sounds oxymoronic. How can you have substantive process? But the law recognizes that, and we actually saw a reference to this in a very famous recent case, the Obergefell case, which is often referred to as the same-sex marriage case. And let's talk about what substantive due process looks like. It's often hard to illustrate it, but there's one example that really sticks with me. I'm not sure you know the history of this, but immediately in the aftermath of World War II, the United States and Britain and others occupied Germany, and German courts, the German court system internally, continued to operate almost continuously from the fall of the Third Reich to the occupation and reformation of Germany. During that period, the German courts were applying German law in many cases. They had to deal with the basic things that courts deal with: divorces and trusts and estates and all of these things. And among the things that were occurring there were soldiers who had deserted the German army were being prosecuted for desertion, often put to death for desertion. And I will say that from the records I've seen, most of those German courts followed their procedures absolutely to the letter. Much the way German trains run on time, German legal process tends to be very exacting and very equivalent for just about everyone. But there's something really fundamentally disturbing about the idea that people deserting from a war that was considered to be evil and in violation of international law, that those soldiers would be executed by German courts for deserting from that war. In an American perspective, what this signals is substantive due process. Occasionally, the process is doing exactly what it's supposed to do, but it's generating results that make no sense. Someone's got to look at the bigger picture and say, what's really happening here with the process? More particularly, and I think this is even potentially even more abstract, due process may be the single deepest compliance mandate in all of Anglo-American law. And when issues, really fundamental issues of compliance, come in front of the Supreme Court of the United States, it's often a retreat to the fundamental due process moment that is where we go. It started with Magna Carta almost a millennia ago, and you see it visible throughout English and American history from time to time. Is it any real surprise that Dixon in Alabama, the case that many of you know well, that first brought due process to higher education back in the 1960s? Is it any surprise that a court struggling to figure out how to deal with civil rights issues in the South, and really having not a lot of law at that time to latch onto, would latch on to the most basic principle in all of Anglo-American law, due process. I want you to think of due process as having a deep texture to it. It's not just about following rules or having regular procedures. Those are very important things. It's not just about notice and comment, but it's about a kind of concept of fundamental fairness that really surfaced again in the same-sex marriage case. The court focused on the idea of fundamental values and fundamental fairness in the United States, and it goes beyond just following all the rules. Sometimes when we follow all the rules, we find ourselves doing the most unfair things of all. And it's a word of caution that's been in our legal system for 1,000 years, is you just can't hide behind your procedures and policies. You've got to evaluate them and see what the real impact on people, how they live their lives, and whether they have become more or less free with the rules that are out there, whether you're actually accomplishing the objectives that you have. So the substantive due process person inside of me steps back, for example, in Title IX and asks a question all Americans should ask. Are the new Title IX mandates actually working? We've added a lot of procedural requirements. We may be following them, but is this really the pathway we should be on? I have my thoughts about that. You obviously will have yours, but it's important to ask that kind of question. And that, my friends, is what substantive due process is really all about. It sounds abstract, but it's actually pretty intuitive when you think about it. Due process. Now, due process is a legal term. And of course, it's manifest in our Constitution. We often think of due process as associated with public law. I work at a private school, and sometimes it's kind of funny because I work at a private law school, and I'll have students come to me and they say, you owe me due process. And I'll say, well, not necessarily, because I work at a private school. And our relationship is primarily contractual. So you can argue about whether our process is fair in accordance with our contractual arrangements in the student code, but due process doesn't generally apply to the work that I do in a private school. However, things have changed, and actually they've changed quite a bit in recent times as the federal government has projected Title IV funding mandates. In other words, we're taking money from the government directly or indirectly. Title IV comes with conditionality, and increasingly the regulators are telling us that if you take the money, you've got to run systems that have respect for due process. Or to put this another way, a lot of public law that traditionally applied to public schools only, is now being projected through the back door of compliance with Title IV funding mandates. So where we are today is a lot of due process is coming to both public and privates primarily through Title IV compliance requirements, funding requirements, the fact that we have been so connected with federal funding. Now, the interesting and I think tricky thing about due process is that there's an overlay with it. We are, of course, always responsible to follow the material and substantial promises that we make to our students, so-called contract law. And we make a lot of promises, so we would have technically an independent responsibility if we make a promise about process. It's going to be enforceable in contract law, conceivably. And actually, a lot of lawsuits against institutions proceed primarily on the theory that we did not follow our own process, which has a due process overtone to it, but it actually often sounds as a breach of contract claim. Now, where this gets particularly tricky is that due process actually is sensitive in part to what we promise. So that when we think about public law mandates about due process, courts will often factor into their thinking and analysis as one feature of that is what's been promised and what's expected. And so you see this really intriguing interchange between promises and core concepts of due process that might exist in the absence of promises. The result that's actually occurred on a lot of campuses is you see people promising quite a bit more process than due process, and again, I emphasize that specifically just to put emphasis on the concept of DUE process, try to get that sense that it could be theoretically separated from what we promise. Minimal due process, often we're promising quite a bit more than what we have to promise, but because we've promised it, we now actually may have contractual responsibilities, and then, intriguingly enough, it actually influences the very concept of due process itself. This is something you might want to chew on a little bit. Most of us see the same thing out there. Institutions have a habit of promising a lot more than they have to, and sometimes we get into the habit of promising things that we struggle to deliver. We also have a tendency to explain to our populations our concepts of due process in very legalistic terms, which may not be particularly accessible or understandable to the populations that we're dealing with. We now have an entire professional organization of a very large number of people or members devoted specifically to fair and due process on campus, ASCA. This has become a professionalized field. I remember when it started many, many years ago. And yes, the so-called folklore about Professor Bickel and Gehring is actually true. This is how the organization came into being. So if you know this folklore I'm speaking of, you can nod along with me. I remember watching ASCA grow and the professionalization of the field develop. Why do we have professionals? Well, it's pretty simple, because we're using pretty complicated systems, and it takes ever more professional people to manage those types of systems. As a result, what I'm noticing on campus is a congruence that's very obvious. When you go to virtually every campus in America, we see codes and lots of code administrators, professionalism and legalistic codes of some kinds. They tend to break into two camps, although there's a lot of hybridization out there. Some codes emphasize a more discipline, a focus. They tend to be written around model codes written by Stoner. Edward Stoner became a very powerful figure in the field, and so you see a lot of folks mimicking or just using Stoner codes. You see folks that are using honor codes, and Gary Pavella and others have been very prominent in leading the honor code revolution on campus, if you want to think of it that way. And really, these two different types of codes are out there, both very legalistic in their own way. One a little more discipline-oriented, the other a little more oriented towards student involvement and ownership of the code. Many campuses, again, hybridize that to create some amalgam of the two. But what's very common is you see codes and code administrators. And in fact, you probably had this phenomenon on your campus. You've had a code, you go to fix it, you try to make it simpler, and you go through the code revision process to simplify your code, and it gets bigger, wider, and thicker. Codes tend to grow, and codes also have a tendency to multiply like triples. So imagine if you look around your campus now, there are many codes, housing code, parking code. Sometimes when I do forensic code work on a campus, we discover codes as we're going through the forest of rules and regulations, codes that not everyone was aware that occurred and existed. And there's a tendency to be imitative of this kind of way of managing on campus. Virtually all the codes have similar features. You'll typically see a preamble, "We the people of the University of X, in order to form a more perfect union, to establish equal rights and regulations." Paragraph or two, sometimes a page, leads into the code, and then we get right to it. Rules, procedures, sanctions. The rules are typically quite familiar. In fact, to be honest, a lot of them look a lot like what I was trained on when I was a student in Catholic school as a young man. Don't steal, cheat, lie, and hurt people, and then some other things. Pretty familiar stuff. Now, of course, we've added a lot in recent times, particularly around sexual misconduct. Lots of rules, often written around legal standards, sometimes actually literally mimicking the legal standard that would apply in another scenario. Procedures, again, we've talked quite a bit about that. Procedures differ. I think the one distinguishing feature in procedures is the extent to which you utilize students and faculty in the procedures. And a lot of schools are very invested in using students in particular, sometimes faculty, in decision-making roles. The more student involvement you have, the more similar your system looks to be an honor system. Honor systems, of course, sometimes have specific types of rules written around honor. That's a whole subspecies, but again, very similar and recognizable features. And then sanctions, and the sanctions also are pretty predictable, going from an oral warning to a written warning to suspension short-term, suspension long-term, expulsion, fines, community service. There might be some restorative justice elements running around in your sanction area. That's become quite popular today with a lot of campuses. And of course, my personal favorite is expungement, where we erase all memory that someone had ever been attending the institution. And it is very similar, actually, to excommunication. So I joke a little bit about this only because it is true that our codes developed in part from our ancient religious histories. You can still see vestiges of that. You can also see military code influence in a lot of what we're doing. Something has changed, and to the margin you see the CCO, CPO language. Why is this here? After the Kent State incident in the early 1970s, well, 1970 in particular, America really had to wrestle with how our campuses were managed. And in the wake of that horrible shooting at Kent State, a very clear message went out to the U.S. institutions. You better find a way to manage your campuses so we don't have to call in the National Guard and people get hurt. We've got to deal with this. And you will notice if you do any forensic code work that a lot of American institutions developed their first modern codes in the wake of the Kent State incident. Some had already been there, but many picked up new techniques. And I think they felt they had to because the federal government was hinting that if we didn't do it, there would be real trouble. In came code administrators as probably the single most important people on campus managing the campus environment. We've relied very heavily on our codes to keep the peace, to enforce academic integrity, to express our values, to use process that incorporates fairness and inclusivity. Our codes have been the battleships of our Navy. And yet today, in Compliance University, something is shifting. The power structure is definitely moving towards chief compliance officers and chief policy officers, because today, whatever codes we have to be compliant with regulatory mandates. And this has become exceptionally visible in the Title IX world, where the government told us we have to have grievance procedures, and you can keep using your discipline codes so long as they meet the standards of federal compliance. And I imagine that you have struggled with this mightily, as we all have, trying to decide how will I deploy my codes and maintain them in the face of these regulatory mandates. Can I even do it? We even wondered how much student involvement can occur in some decision making on certain issues. So for those of us that have relied heavily on honor codes, the very concept of an honor code is under attack in the compliance world. But I think most importantly of all, the preeminence of the battleship in the Navy, which was once the code and the code administrators, being challenged by a new type of Navy that's relying on aircraft carriers, I suppose, and these are the chief compliance officers. Even the pay that's being attracted to these jobs is differential. And again, I suspect you're seeing this change on your campus already. It's one that's been accelerating recently in light of the new Compliance University world that we live in. Couple of observations about codes. Let's imagine that I land from a foreign planet. I'm an alien, a space alien, and I say, take me to your leader. And one of the things I notice right away is that most people in higher education don't trust each other to make final decisions. Our codes are very, very concerned about making mistakes. And so therefore we review everyone's work. I've been to campuses that have so many levels of appeal that it can take the better part of a year to resolve even fairly simple matters. Again, you have to look in the mirror to see where you stand with this, but mistrust of decision making is really actually quite visible in a lot of our systems. And just a word of advice with this, you can make mistakes by over-processing things just as much as you can by under-processing things. You can make mistakes by over-processing things just as much as you can by under-processing them. So as you evaluate the systems you use, please keep in mind that there is such a thing as super duper due process, and that actually might not be due process. It might be too much process. There's certainly products on the market that are so over processed, they're actually unrecognizable from their original ingredients. There's a lesson in that. I also noticed landing from this foreign planet that we're very legalistic and very focused on objective determinants of human behavior, rules. This is fascinating to me because our populations don't really come to campus as lawyers. So legalistic terms are off-putting to people right off the gate. They don't really often read our codes. If you've done code administration, and I have, I frequently hear people say, yeah, I read the code, but I didn't realize that was the rule or how it applied. And part of the problem is it's written in a language that's off-putting. There is also a focus on objective determinants. We like our rules, and we really emphasize rules as determinants of human behavior. But keep in mind that human beings are also guided by other things such as values and standards, policies, etc. And I think as we evolve our code thinking into Compliance University, we're more likely to start focusing on different kinds of standards for human behavior and conduct, and not necessarily always focusing everything that we're doing on rules or so heavily. You'll often notice that our codes are referential to other systems. For example, state law, specific state mandates. Or on a number of campuses, you should also see that the multiple codes refer and crosstalk with each other, adding a level of complexity and confusion. It can be very difficult for populations sometimes to figure out how the interlocking codes work. The people who administer the systems often have a good sense of the play of the game, but the people who come to the game new often struggle with it. I've noticed watching football games, for example, I don't think that you could learn the game by reading the rule book. You'd actually have to play it and referee it to have a sense of how it really operates on the field of play. A lot of games are like that. You can't really imagine what it looks like unless it's something you've had experience with. And this itself, I think, is a challenge for a lot of our codes. We just assume that people can pick them up and understand them, or we don't really focus on that issue terribly much. I suppose this is a good place also to just make sure we understand that many of our students, particularly millennials, are not really rule people. I teach law school. Many of our modern students, particularly millennials, are not particularly rule people. They weren't raised the way I was necessarily. I grew up under Depression-era parents, and rules were common. I went to Catholic school, lots of rules, consequences, punishment, forgiveness. This was part of how I grew up, was learning around rules. Gosh, when I went to college, I studied philosophy with philosopher John Rawls, and I was thrilled to do so. And his major book is called A Theory of Justice. And I want you to stop and think about that for a minute. A theory, a metacognition about justice, which is also a metacognition about rules. I love that. That to me totally made sense. Let's have two levels of abstractions around rules. And I couldn't wait to study that. I also had games that when you'd open them up, you had to read the rules before you played it. They were on the inside cover of the box. But today, a lot of folks, when they pick up a game, it's plug and play. They're not looking to have to study a rule book before they play the game. And a lot of young people have been mentored and rewarded and even bribed to get the behavior that people want them to have. So I go to fast food restaurants now, and they have the exciting kids meal that has a toy in it, and you'll often hear parents saying, if you do a good job, you can have that meal. To me, just being able to go to the restaurant was a reward. I see a reward culture, not a rule and punishment culture. Mentor reward as opposed to rule and punishment. So I think actually a lot of our students today come to higher education and they're really confused by how we try to manage them, because it's coming from a different polarity. It's coming from lots of objective standards, severe consequences, rule application, oppositional. Sometimes they refer to us as haters because of that. We're not mentoring them in some of these processes, and as a result, it's foreign to them. So there are a lot of challenges, I think, with some of the codes that we're using. And it goes fundamentally the types of people that we're teaching and what their orientation is. Again, this is an overgeneralization. It's not true for all populations at all times, but you will notice this if you do a lot of work in the field. Our codes are slow to change and difficult to manage. It can take the better part of a year, sometimes 2 years, to change a code. And as soon as we change the rule, students modify their behavior around it, and we need more rules. So back we go to the lengthy code revision process. But even more fundamentally, compliance time and code time don't match up. So our codes may tell us we need to go through this process for revision, but the regulators tell us you need to have these rules right now, immediately. I think this was the great challenge in Title IX. April 4, 2011, a letter comes, "Dear colleagues, do all of this immediately." We weren't prepared to do things immediately. Our systems were designed to do things not immediately. And so we're literally having to retool our very conceptualization of compliance time and rectify it to code time. It's very common to see process divided between academic and conduct, a distinction I've always thought was false and misleading. It's common, and a lot of it has to do with the politics of a campus. Faculty often want investiture, or students do, over certain kinds of core academic offenses, particularly plagiarism and academic integrity. But when you really come right down to it, every issue that comes on campus is ultimately an academic issue. And so we can call it a conduct problem, and that's certainly our right to do that. But when you really come right to the chase with it, if people are acting out, it's causing an obstruction in the academic learning experience, and so it is ultimately an impact on the academic enterprise. Part of what's happened is a lot of our work has been pushed to the side and styled as conduct or administrative. But as I've been pointing out in Compliance 101, the luxury of imagining an underclass of employees who are academics is something Compliance University just does not recognize. Today, it's the work that we do as student affairs administrators with so-called conduct issues actually go to the core of the academic enterprise. And the luxury of imagining student affairs professionals as non-academics is something that Compliance University simply doesn't recognize. There's going to be a lot of pressure on institutions to rectify the status of certain professionals on campus to the academic mission. Obviously, we should be and we need to be pushing for this ourselves, but the law itself is pushing us that way. Compliance University is changing the imagination of an academic staff and a non-academic staff. So we've been talking a lot about fair and due process, and it's pretty clear that our concept in higher education of fair and due process has been heavily influenced by legal concepts of due process. It's interesting that the courts themselves, the Supreme Court in particular, has pointed out that due process is the process that's due. And even under Supreme Court metrics for due process, we're directed to make sure that our processes are context specific and appropriate. And so it raises sort of the most obvious question is there a better way to do process, to do it, D-O, do it, as opposed to D-U-E it, on our campuses? And I'd like to sort of tweak your thinking a little bit, because as we move deeper into Compliance University, I think we're going to be challenged to come up with new types of process thinking to manage our environment. Is there such a thing as educational due process, higher educational due process?